I have made you co-host.
You
Good morning, everyone. Today, I welcome you all to the fourth session on Workshop Series 10 on Perspective on IBC. Today, we have with us Devvart Rana sir as faculty for taking session on topic Strategies for Making Exit from CIRP.
Good morning.
Let me briefly introduce sir. Sir has over 23 years of experience in real estate, hospitality, and infrastructure sector with firms like DLF, Lee Meridian, VTA Star Dubai, etc. He is an insolvency professional. He has successfully handled multiple assignments under IBC. Currently, he is partner at Triple R Insolvency Experts LLP. He also represented resolution applicants in different COCs under CIRP and had prepared resolution plans for successful resolution applicants. He also advises and acts as advocate in different CIRP matters. He is currently acting as legal advisor to state-owned companies like Maharashtra State Electricity Transmission Corporation and empaneled with different banks for insolvency professional services. Now over to you, sir.
Thank you, madam. Okay, we can start. As Anjali said, we are, I think, on fourth day, right?
Yes, sir.
People, since you are here, all of you, I request only one thing. If we can keep it as interactive, it's a small topic. Uh, if you want to just read it, it might finish in 30 minutes. But if you interact, it can also go to 3 hours, 4 hours as we want, right? Uh, it's an interesting topic, which is exit from the CIRP. So we'll try and look at it from different angles. In the sense, one is so last 3 days, what you have been learning is role of RP under IBC, timelines, milestones under CIRP, resolutions of dispute under CIRP. And I think tomorrow you will also learn post CIRP implementation. But today we are doing something different. We are saying, what if there is no CIRP now? Or let's say it has started, we don't want it to continue, or somebody doesn't want it to continue. Then is that possible? And if that is possible, how is that possible? So if that possible, obviously has an answer yes, which was not envisaged in the initial time. When the code came into picture in, anyone who can tell me? 2016, right? 1st December. And when this 12A, if anyone is aware of, when this 12A came into picture?
2020.
No, sir. Anybody else? Without research? Anyone? Okay. So it came in 2018. So 2020 was too late. I mean, it doesn't take 4 years to realize that, there is not something missing, like, option of removing it. Initially also things were happening, but they were happening under the section 60/5, which was, general power of the court. Then IPPI on 6/6/2018 came out with this amendment. And that is why whenever you have this A or B inserted in between, these are afterthoughts. And afterthoughts means initially they were not envisaged, but when we saw a lot of things happening in this area, we tried to introduce as an amendment and brought this thing into picture. So let me start my presentation here. I made a very small one, though we don't need to focus on that. It's more about interaction. I will show you some orders also, which are like from different spectrum, right? From day one, let's say your CIRP has been admitted today. and withdrawal may happen tomorrow also, or it may happen at the last fag end also. So whether all this is possible or it's not possible, we will learn that today. So I'm sharing my screen now. Any question, please feel free to stop me. Uh, I don't get disturbed luckily. So whenever you want to stop it, let's stop. We will discuss it. If there is something which is already coming in the new next slides, then I will ask you to wait for some time and then we can discuss it. Fine. I hope my screen is visible now.
Yes, sir.
Yes, yes.
Yes. Okay. Thank you. So we'll go to our slideshow. So today this is our topic, strategy from exiting from CIR. Now, when what do we understand by this exiting? Exiting means closing, right? And closing can be from many sides. One closing is the process is closed. Is the RP also discharged? Or is it from the RP side that it's going on for ages and ages and ages? When is it going to finish? So one way of exiting CIRP is going into liquidation also, isn't it? CIRP is a process which may lead to liquidation, right? If we are not able to resolve it or if it's not viable, it will automatically go into liquidation. Now that is also exiting from the CIRP, because why do you need to run this entire process for 6 months or 9 months when we already know that there is no viability? Can we go directly for liquidation? So we will discuss that also today. Okay. So today's contents will be strategies, manners, and type of exits and timing of exits. Right now, we are saying exit from CIRP. This is for old management. Old management wants to take their control back. If the business is still viable, older person doesn't want to leave control, they can ask for regaining of control. Secondly, if it is totally unviable, then also we can close it and send it for liquidation and story is over. Third, all litigations, claims, claimants, exiting from that era, that is covered under 32A also of our act. Uh, Another aspect to it is discharge of the RP and exit from the formalities of the processes. As I said, we keep, hanging this trophy in our neck that, that it's a CIRP going on. I have one CIRP case going on for last 4 years and nothing is happening. It's not even a going concern. And we are not able to do exit. So though we are discussing exit strategy, there are strategies in place, but at times we do get stuck. We'll try not to, get into that mess. And if we get into that mess, how we can try and come out of it. Another way was, though the topic says exit from CIRP specifically, but it's also exit from liquidation, unlocking of your leftover values, etc. If time remains, we will go through this also, like what is dissolution of CD, how the IP is discharged, how can we sell it in piecemeal basis, etc. If not, then we'll conclude at our exit from CIR. Now, anyone has read that BLRC report, or if might be somebody must have discussed in your last sessions? BLRC was, what was BLRC? Anyone?
Banking Law Reform Committee.
Correct, sir. Absolutely right. Thanks for sharing, sir. BLRC report was the basis on which this law, this code came into picture. IBC 2016. So they recommended, it was like a constitution of this IBC code. They said that,
Uh,
okay, why don't we do this? Why not genuine failures gets a proper exit from the business? So if the business has failed, or let's say the promoter has failed, or situation has changed, macroeconomic factors have changed, then that exit should be allowed, an honest exit. It's like otherwise entrepreneurship, uh, when we reward, we also reprimand. So entrepreneurship is rewarding, yes, but if it fails, it takes away everything till now. So now when IBC code came into picture, they said, fine, you tried, you gave your best, you did honestly whatever was possible as per your skills. Now, if the business has still failed, then it's okay. You leave the company, we will sell it to somebody, we'll appoint one RP. If you are not able to do it, you come out of the picture, we give it to someone. Let that person try. If it can be salvaged, it's fine. Otherwise, whatever value is left, we will take it, distribute it, everybody go on their own way. Right? That was the whole idea behind IBC code. And that is why we say ease of doing business includes ease of exit. So CIRP was specifically formed for this purpose. Now, because of this, India is now the best performer in South Asia on resolving insolvency, and it does better than the average OECD high income economies in terms of recovery rate. So recovery rate, some bankers might not agree. They might say that, in surface team, we had better returns. Uh, CIRP gives around 29-30%. In some cases, it's not even 10-20%. There are all kind of cases. So CIRP was not a recovery mechanism any which ways. So finding out that what CIRP is offering them and then comparing it is any which way is a wrong comparison. Secondly, cost of proceedings, if it's not a going concern, then cost of proceedings are pretty less. Yes, if it is a going concern, then CIRP cost might look bigger, but that CIRP cost looks bigger only because there are running expenses. That is why. Otherwise, cost of proceedings under IBCs are not that exorbitant. Uh, Another way, India doing business ranking as per the latest banking report, it has improved a position from 142 in 2015 to 63 in 2020. Uh, I mean, it's a little older data, I guess, but we are nearly that range only. Nothing much has changed in that last 4 years. Easing the process of exit, the government in 2016 introduced IBC, allowing failed firms to exit painlessly, either through quick liquidation or business restoration when viable. As a result, the average time to resolve insolvency has declined from 4.3 years to 1.6 years. Uh, I think practitioners who are here, if many of you are here, we can agree on this to some extent because initially things were not really clear and everybody was running to Supreme Court for taking decision. Nobody gets satisfied at NCLT or NCLAT, they'll straight away go to Supreme Court. So from NCLT, you can challenge in NCLAT in 30 days plus 15 days. And from NCLAT to Supreme Court, you get 45 days and 15 days of grace period. So around 2 months. So 3 months can go in this very easily, even after everything is going at its super fast pace. So time was taken. Initially, time took because, when you make the law, everything is not correct in the book. There are so many amendments which have come. Those amendment came because there were some slight lacunas here and there. So initially it was taking extra time. Though right from day one we envisaged that it should be 6 months time period, 180 days plus 90 days only. It never happened. It was not there. Now yes, it is improving. At least the decisions are coming faster. This is theory. I think we have already discussed. We don't need to check it out. Now, what does 12. Anybody has read 12A? What is 12A before going to this? Anybody would like to say? What is 12A? 12A is a famous section where we say is the exit, right? Exit route for the companies. No?
Is it withdrawal of application?
Withdrawal of CIRP processor.
If 90% members are okay, then
Okay, that is one part of it. 90% people have to agree. 90% of the COC members have to
COC
agree,
members. Yeah.
right? And it can be done by whom? Who all can file this?
RP can file. I think.
RP.
RP can file it. Okay, it can be filed through RP. But
Fine.
can, let's say the application was started by an OC. The CIRP was started by an OC. He is not in the COC. 90% of the COC says withdraw it. Okay, but he doesn't want to withdraw it. Now,
He
can
will
it
not
be done?
sign.
He will not sign.
He will not sign.
So what will happen? Can you file 12A?
I think yes. The RP would have to take the approval of COC, and then with the results, he can file.
Okay, Mr. Chaurasia, I think is saying it can be filed. Okay, any contrary view? So we'll try to keep it interactive if you genuinely wants to learn. Otherwise, it will become one-way traffic and I'll finish it in 1.5 hours.
The OC must
Yes.
first get settled. Then he will give his consent, and then COC has to pay.
Vaishali ji is coming from the other sect. She is saying
Because only
who has
COC
initiated
it is
the
not
applicant, right?
Huh.
Applicant has to, who will sign form FA? There's a form FA, right?
Yes, yes.
I hope we are all practitioners. So I'm
Yes, but I have not
straight away
done.
coming to that word FA. What is FA type?
But I have not handled this 12A anytime.
No
so
worries, no
I
worries.
didn't know.
I'll be coming there. Good to
I think
have
it
a
is to be
different
signed by
opinion.
COC. It is to be signed by COC and IRP. And first it is to be this OC claim has to be settled. Then pass resolution in COC and then file FA. This is what I think. I don't know. I have not
Fair
practiced.
For
enough,
COC
fair enough.
formation, OC will sign the application, sir.
Acha.
Compromise agreement will be signed.
Applicant will sign, na?
But sir, if you are not
But-
paying anything to applicant, will he sign?
No, after his settlement, no.
Settlement
Oh,
means recovery, right?
Yes, it is.
I said it right in the beginning. First
In this
word
case, he is
was,
OC. In this
first
case,
word
he is
was,
in OC.
this is not a recovery proceeding. It is not insolvency. Please try to keep this thing, though practically we know what you are saying is correct, right? But theoretically, this is not correct. Theoretically, we will not say this is recovery. So his recovery is not happening, but 90% of the people are saying let it finish.
In this case,
It's
two person will arise.
I'll try to keep,
who will sign and who will provide the bank guarantee.
who will provide the bank guarantee? Okay.
For
Okay,
this
good
form
question,
FA,
sir.
bank
Good
guarantee will
question.
be-
In form FA, there is something called a bank guarantee or, payment of the cost till that time. Now, who will pay that one? That is the question, right? Okay, fair enough. Any other question that comes to mind while coming to this? I'll try and answer this last question first, then we will take it up later. Who will provide the bank guarantee is the person who is going to get the benefit. Like in our Evidence Act, we say, right? Now,
CD will
Sakshi
provide, sir.
Adhiniyam, right? Whoever gets benefit or whoever wants to prove it, the burden of proof lies on him. So if the CD wants to take it back, the CIRP, if the CIRP is coming to a closure,
So
obviously
compromise
CD wants to
agreement
give it, right?
between, sir, compromise agreement between CD and OC, and CD will provide the bank guarantee further, that he will implement that.
No, our question was different, sir. Okay, okay, what you're saying is right. We were stuck at a point that he is not settling with the applicant. He is not paying this applicant. But COC 90% is saying, okay, we can withdraw.
No, without the consent of OC, it cannot be withdrawn.
Fair enough, ma'am. So we'll try to answer this question. In my view, it can be okay, but we will learn it end of the session. Right now, because it needs a lot of thinking to go behind it. I will show you. Let me take you through these slides. So this question should keep burning whether if the person who initiated is not happy, still can be made to do it. Right? Because see,
Yes.
he is one OC only. Like him, there are 10 other OCs also. They will also say why he is only being settled, why not we? So we'll come to that. Just hold that question, though I only raised that question.
Yeah, before
Let's,
that, I have one query.
yes, sir.
In case of the CD initiated CIRP, how it will be applicable and why it will be
CD,
applicable?
okay. Sir. CD initiated CIRP. That is your question?
Yes.
Sir, if
Well,
CD initiated CIRP, then who will file 12A? Nobody will file 12A.
so, what is the benefit in keeping it in this section? Section talk about all three, 7, 9, and 10. So
Yes.
I think lawmakers should have something in mind to keep it in this section. So what will be thought around it?
Okay. Fair enough, sir. Good question. And I think to my, humble knowledge, whatever I can, I'll try to answer that. That why 10? Okay. 7, 9, you understand easily. I understand, right?
Yes,
So our
everyone
section
understands.
says, section 12A. So this is it's a very small section, though it just says the AA may allow the withdrawal of application admitted under 7, 9, or 10 on application made by the applicant with the approval of 90% voting share of the COC in such manner as may be specified. Right? Simple. 7, 9 we all understand. Why 10? Now 10 in my opinion is only just to cover up the entire spectrum instead of saying that, oh, 10, if it is admitted, it has no exit option ever, just to take care of that part. See, you filed for your CIRP, right? You wanted to negotiate with, let's say, your debts were there, you could not settle it. Suppose in 6 months, things have changed completely. Let's say you're a thermal power company, let's say, right? Your thermal power company, you are not able to service your debt, you go into CIRP protection, you get into the moratorium. After 6 months, let's say things have changed. There is a new fuel, right? Let's say the coal is now 10 times more efficient than what it was earlier. Suppose some situation like that arises and now you want to come out of it. Do you have an option? Now you have an option under 12A which says that even if it was admitted under 10, even though you yourself had said that, okay, I am insolvent, you can come back.
Sir, here I have another reason for this. Whatever is
Please
coming to my mind.
enlighten us, sir. Yes.
Suppose in case the promoters mischievously file an application, then either
Yes.
COC or anybody can, but because companies otherwise may be solvent one, but because of certain reasons, we can understand. If it is filed, then also I think it can be taken back with the permission of, means the COC certainly will not agree for 90% or so. In that case, I think it may be taken.
No, if COC will not agree on 90, then it cannot be
Then
withdrawn
certainly
any
it's
which
not.
ways.
No,
Right.
in that case, if COC is not there,
COC is not there, then why will
operational
CIRP will
creditors are
happen?
there, means financial creditors are not there.
Okay, OC is there. Now
OC is there.
sir, OC is as good as a COC. So, sir, when we make
Okay.
COC,
Yes, yes,
OC or FC has no difference, right? There is no
yes,
meaning,
yes, yes,
right?
yes,
So,
yes.
whatever COC is COC.
Mm.
So, okay, you are saying if financial creditors are not there and only operational creditors are
Okay.
there,
Then they
they
will form
may
the
say
OC.
that company is viable, why this is going in. Sir. Tell me, I am a body. I am saying my head is paining. How can you decide that my head is not paining?
No, sir, it is not related to head because it is well, sheet and other things, everything is there. If because of certain reasons, because of otherwise importance or that purpose,
Then,
if it is felt that corporate debtor is mischievously want to come out of the scene, in that circumstances, I may think it over maybe.
sir, in
No,
first
but
place,
sir,
in
CIR,
Section 10 application, AA will decide whether it is filed mischievously or not. Every
correct.
case, in this famous airline case recently, the 2 or 3 day hearing was there for whole day.
Absolutely.
So in every case, A will decide whether it is okay or not. So
Sir, that is decided. You are
mischievously,
right. Even before admission, it is decided. It's not
ah,
that at the end
so
only we decide.
question of mischievous application may not arise in before COC, whether it is constituted by OC or FC. Some other reason might be there.
Sir, that's what other reason you can think of, if you would like to. Any other thought that why 10? So 7, 9, we understand why somebody wants to come out. 10, if you went into it, why you want to come out?
One reason maybe, I am not sure, but if there are some heavy recovery maybe in your way and you want to avoid for that
Absolutely.
time and later on you some appeal or through some
Absolutely.
other reason,
Absolutely.
it was avoided and now for the timing you are again in your normal course of business. It might be a
Perf-
reason, I am not sure whether it
Perfectly
will work
fine.
or
No,
not.
no, sir, this is a valid reason. I'll tell you why.
And
Let's say
what
there
you
are
said a
hydro
valid reason,
projects.
sir.
Sir, there are hydro projects, right?
Yes.
In hydro projects, the it takes time to implement that project. Now let us say you have some money due from government which is in crores, and it has happened in one of the case, right, which where this order had come that GVAT, it was in Ahmedabad. I'll not bore you with too many case laws, but where the matter was decided that this CIRP is happening because so CD was solvent. CD is doing some service to the government. Now government just have to pay him. The moment government pays him, he is viable. But till the government is not paying, he is completely unviable.
Yes, I agree for that. I have worked for one company. That time, 12A was not there. So we have debit and credit of about same amount, and recoverable was from government. Heavy recovery should have been come from government only,
Absolutely.
and all the banks are also from government banks are there. But 12A was not there, so that was another issue.
Absolutely. So we agree on this part also, sir, that why 10? 10 because that time when you went into protection, see when the moratorium under section 14 applies, there is no interest which is charged for this 6 months. Because that 6 months you had nothing. How will you service that? And if the clock of interest keeps on ticking on your head, then you will certainly become unviable. So you get into the protection of CIRB till you are getting the money. You are hoping that it happens before the resolution plans, etc. And till the or you drag on the process through some way or whatever. And then by the moment you have the money in your account, that can be paid off and you are suddenly again viable. You go for 12A. So So 12A is only this, but how to get into this, how we will learn that right now, sir.
Sir, one question. Sir,
Yes.
this section 10. So, did the go air case, the creators miss some trick, or they tried this?
I
It's a
am,
good question,
sir,
and
they certainly tried this, obviously.
Okay.
So that was the whole idea behind going under 10, right? That, you don't want everything on your head. Moratorium starts, RP comes, you always have a 12-way option. So at least 6 months of peace of mind you will get. That was the whole idea behind going what we can understand
No,
from
the
our.
creators could have also tried for 90% and then uh, withdrawal of application.
Sir, when withdrawal happens, it goes back to the same promoter.
So at
So,
least,
so creditors, why will they do it?
now
Creditors will
they are
never do
facing,
it, sir.
at least they are now facing liquidation. So they knew if they had tried that way, I think that would have been more feasible.
No, please elaborate, sir. I didn't get you. So you are saying creditors took them to
No,
NCLT?
no, I am telling since Go Air promoters CD went under section 10 to CRP, the committee of creditors should have voted and tried for withdrawal of application. So it could have been again back to normal.
sir,
Sir,
it might be one thought, but
that is what you are saying. No, I am saying my head is paining. How can you
Ah,
say that it is not paining?
that is true.
So I have to say, and you have to agree by 90% voting that yes, now I'm fine.
even in such case, QOC will look into the account, and in this
Yes,
particular case,
yes.
there are huge OC amount for these aircraft land rent and hangar charges or all these. So there are heavy charges to pay, and the initial report are there that they say CIRP was for to avoid these charges to foreign countries.
Absolutely, sir. Moratorium applies on
But it might
everything,
not work
right?
well.
Sir, so, case specific at times it becomes interesting, but we are talking about general scenario also where 12A is happening on so many things. Right, I have seen in my personal, I have the experience of doing 12A in 3 cases. I was appointed in 3 matters, and 3 matters were withdrawn. One was withdrawn on day 1, one was withdrawn on day 3, and another one was withdrawn after liquidation. So this is being utilized quite heavily. 12A is one of the most talked about section, and it's important to understand the intricacies. And again, we are all learning, sir. So like the first question I put it in the beginning, I still think even after answering all the questions, we all will still be divided whether it can be filed or it cannot be filed. Because if everybody is of the same opinion, then we don't need so many courts. Then we don't need NCLT, then NCLAT, then higher bosses, and then, then it would have been good, no? If law is so easily understandable by one and all, then there's no need of higher courts. So we'll try to go through these slides. I'll try to show those orders also, how Form FA is given. Form FA, somebody was mentioning that the bank guarantee. Sir, this bank guarantee is normally, I don't think any RP is taking bank guarantee unless it is in multi-crores. If there's,
I
normally these
understand that.
applications are settled in first month, very initial period only. That time they say, okay, if it is 5 lakh, 10 lakh, you put up DD to it and we finish it. Because who will go and, work around the BG part?
Yes, yes, yes.
So,
Agree on that one.
so there are, so section is 12A and the related regulation is 30A. Regulation 30A, which is withdrawal of application. What does 30A says? An application for withdrawal under An application for withdrawal under Section 12A may be made to the adjudicating authority before constitution of the committee by the applicant. Obviously, if there is no committee, then only applicant can go. After the constitution of the committee by the applicant through the IRP or the RP, provided that where the application is made under clause B after the issue of EOI under 36A, applicant shall state the reason justifying withdrawal after such issue of invitation. And these, we all know the reason, right? They all say that now it is viable, which is good enough reason, right? Doesn't hold you. So, before the constitution, after the constitution. That's all. Nothing says, nothing much. Second
But it does not
point says,
say about liquidation. It does not say anything about liquidation process.
sir, it's not yet there. We are still in CIRP. We will come to liquidation. Liquidation, we go to 39. Regulation 39BA and 39C. And there are other ways also of exiting CIRP, not only 12A. 12A is one of the way. We will see that, sir, how it is. So right now 12A, 30A is the regulation for that. 30A subsection 1, 30A subsection 2. Subsection 2 says application under 1 shall be made in the form FA, which is on schedule accompanied by a bank guarantee towards estimated expense incurred by the RP or the RP till the date of filing of the application. Towards estimated expense incurred for the purpose of clauses, all the clauses above. They only say till the date of filing. They don't say after what. And normally, at times, these applications may take 3 to 5 months also. So the law does not say that they have to pay for 3 to 5 months, but it does take 3 to 5 months at times. So this is RP's intelligence, how he convinces the COC to inform that how much time it might take. Where an application for withdrawal is under clause A of subregulation 1, IRP shall submit the application to A on behalf of the applicant within 3 days of its receipt. So within 3 days means it came and you finish it. That's all. So even to make affidavits, etc., it takes 1 day, right? So they want that it should be done then and there, suddenly. Now, how do you make this? So wait. Why would they say 1 is? If before constitution, you do it within 3 days. If it is after constitution, then you will have to call the COC. COC shall decide within 7 days, and then you file it accordingly what the COC say. Where the application referred to in sub-regulation 4 is approved by the committee with 90% voting share, the resolution professional shall submit such application along with the approval of the committee to the AA on behalf of the applicant within 3 days of such approval. Adjudicate authority may by order approve the application submitted under sub-regulation 3 or 5. And it says may approve. Okay, it doesn't say AA shall approve. AA may approve may approve the application. So they are not bound to approve it. It's their prerogative. That means this part is justiciable. Okay. Where the application is approved under subregulation 6, which is above, the applicant shall deposit an amount towards the actual expenses incurred for the purposes referred to in clause A or clause B till the date of approval by the AA as determined by the RP or IP, as the case may be, within 3 days of such approval in the bank account of the CD, failing which the bank guarantee received under subregulation 2 shall be invoked without prejudice or any other action permissible against the applicant. And now the applicant was your IRP or RP, whoever, right? I hope this is clear, or do I need to elaborate it?
Here, sir.
Okay. So strategies for exit. Section 12A of the IBC allows for withdrawal of insolvency by the applicant if the COC member approves by 90%. It is observed that the commercial wisdom of the COC to accept or reject a withdrawal is also taken into consideration, but final discretion rests with the adjudicating authority. Here, in this also, BLRC committee had discussed that once a bankruptcy petition, and when we say bankruptcy petition, it's like CIRP petition or any petition, is filed, it cannot be withdrawn without the leave. And when we say leave, it means without the permission of the A. It cannot. Now, withdrawal of CIRP before admission of appeal. So, there may be a situation when applicant, after filing the application of insolvency under section 7, 9 or 10, please read it as 9. 7, 9 or 10 of the IBC wants to withdraw the application before it has been admitted, as they may have arrived to a settlement. In such situation, Rule 8 of IB, rules of application to AA, it says it provides for the provision for allowing the withdrawal if the NC application has not been admitted. NCLT may permit withdrawal before settlement. So this is pretty straightforward, right? If two people are fighting, one of them agree, then straight away you withdraw it, right? And in such cases, courts normally don't get into the uh, merits of the matter so much until unless it has been heard and reserved and all. So if they are at the argument stage, if one person is not arguing, you may go back. Normally, in case anyone of you are advocates here and you are planning to appear for some of the party who is withdrawing it, just a word of caution. If you want to withdraw, you may mention that we are withdrawing it with the liberty to file. If the agreement fails or something, it's up to you. But try and incorporate that, because if you'll try to initiate the process again on the same grounds for which you have withdrawn it, then there might be a problem on that, because then it will come into re judicata, or it's already decided kind of situation, and it might trouble. But it can be withdrawn, yes, anyone can withdraw.
But means if it is agreed that they will pay and
Yes.
they don't pay.
Yes.
So that is why we have to mention that without prejudice, we can apply again. Is it?
Ma'am, normally what happens, since you have brought it, let me bring to your notice. Once, and this matter went up till Supreme Court. So there was a petition which was going on. Uh, it was an OC who was filing it. So it was an operational debt. Fine. Let me put an amount of 10 crores. Fine. So CD said, fine, I'll pay you 10 crores, but I cannot pay in one go. I will pay you 1 crore each for next 10 months. So first installment was cleared. Next installment onwards, nothing happened. That's all. So one crore they got. Now they don't have now they have already withdrawn it. Since they have withdrawn it, you have already gotten into the agreement. Now what happens? What do you think? In such case, it should be revived.
I think the court does not allow this. That is why we should not do like this. Instead, they should pay in one go.
You are saying court does not allow it
I
to
think
reinstate, right?
Mm.
And any other view on this? Anybody else other than Vaishali?
Because in my case, one the the CD, the promoters said that we will settle in tranches. But then my advocate told no, they you should not accept this. Otherwise, if they fail, then the court will not allow again to have a Section 7 petition. This is what I was told, but I don't know why.
Sir, in my opinion, if law of limitation permits, then it can certainly be allowed because debt is already there.
Fair enough. Good. Somebody is bringing law of limitation into picture. Okay. Any other opinion? So you're saying as long as 3 years has not, or law of limitation
Exactly.
is still
Yes.
not there, and as long as we are crossing the threshold, right? One
Yes,
one
yes,
crore.
yes.
But suppose you had sir, even in air people are so smart. You know what they're doing?
They will
If it
reduce
is,
it to
let's say
below
1 crore
1.
10, they bring
Certainly,
it
generally.
below 1 crore and then
20.
they stop it.
I think then you have no option.
that-
It cannot be.
This I have heard, that they bring it with the below 1 crore and then stop.
That's why
Yes.
smartly you have to play, and at least it should not below 1 crore. But they pay in your account even and get it reduced. Then
No,
in
but
case
what about 10 crore, sir? I gave you an example just now. 10
Yes,
crores, they
yes,
paid 1
yes,
crore. Now you still have
yes,
9 crore left. What do
yes.
you do?
I think in that case it can be filed because that is more than 1 crore and law
You think so,
limitation
right?
permits us.
With
And-
liberty to
and-
file only.
If
Unlike
you have the
other
liberty
case,
to file, you are saying, right?
Yes,
Yes,
yes.
So everybody is saying that, yes?
I think so.
Sir, in one of the cases, same thing happened. NCLT said, sorry, now it is not admissible. Fine. They went to NCLAT.
Agreed. Yes.
Appellate also said you cannot file it. Forget it. They went to
Supreme Court. Okay.
next level.
Yes.
There, Abhishek Manu Singhvi ji was appearing for them. They said, sir,
Okay.
what the hell is this? And
Yes.
you will be
Certainly.
surprised what the reasoning was.
Yes.
Reasoning, what could have been the reasoning of NCLT in denying? When all of you sitting here who are, might not be as learned as our honorable judges,
Exactly.
when you say yes, why they said no? Why they would have said no? See, we are not demeaning anybody. Everybody has opinions, right? So this is only an opinion. Why they
I
would have
think
said? There must be some reason, right? They must have
I
thought of
think
some.
company may be very bigger. In comparison to that, this amount may be a smaller one. That is the reason.
Oh, sir, 1 crore is 1 crore.
1 crore is
Company
more
may
than
be
1 crore.
Reliance. How
As
does
per
it
law, it
matter?
should be. Yes,
As
certainly.
per
You are
law,
right.
it's 1 crore. What
1
can be
crore.
their reasoning? I'm trying to.
that may be you are trying us as recovery proceedings.
That is the only thing.
That might be only thing, I think.
That it cannot be used
Okay.
as a IBC mechanism.
Recovery
Cannot be
for
used as a recovery mechanism.
Fair enough. That one
Yes.
is
In-
one
Sir, in
one
one
way.
case,
Okay.
in one case, the compromise agreement got failed. And the OC again filed with the Honorable NCLT. Honorable NCLT has admitted it, and they appointed me as a RP.
Yes.
So it is obvious that it should be, but reason
No,
what I
sir.
don't know.
We are not saying. So we are obviously they will accept it now because after
Yes.
Supreme Court said what are you doing? So they are accepting it. No doubt
Okay,
about
okay,
it.
very well, very well, very
Now
well.
even the advocates have learnt it. They
Yes,
say that we are filing it based on so and so agreement. If this fails, we have a liberty. Please don't stop it for this reason.
okay, yes,
But
Hmm.
this has happened, and what is the reasoning they gave? You will
yes,
love it. The reasoning was the debt which you came here as. See, our definition are in section 5. So section 2.
yes,
So
Hmm.
section 2 says definition of an operational debt is
Yes.
that you provided services. It is due and default payment of an operation creditor admit under section 9. But now you have made it a contract. Now this is a contract debt, not an operational debt. Contract debt is not covered under IBC. Now we are not talking to you. Thank you. Go ahead. It's over. You have civil remedies, you have civil court, suits, you ad valorem, whatever you have, go to district courts, take it from there. NCLT is out for you.
Ridiculous only.
You are saying ridiculous, sir. It came out from NCLT, from NCLT also accepted it.
Happens, sir.
Saying that this debt has changed its color from operational to contractual.
Debt to contractual debt. Okay.
Now the issue is, now when it will go to even higher courts, there they said, sir, and you know the reasoning of the other lawyer who actually got it reversed was, he said, color of the cow will remain same, whether I will tie him on this tree or in the next tree. How can the
Exactly.
color of the cow will change?
So,
You are changing color of the cow. That
and
operation, the debt arise
yes,
because of an service.
yes.
We came to you. They said, okay, we'll agree to settle. Now they did not settle. How the color of the cow will change?
Yeah. Means basic things cannot change. And the concept of lifting of corporate wealth, it applies here, then also it should be. So, though it is in a different context. But with regards to debt, because original debt is original debt. Originally, it is a operational debt.
So, if some of you are not lawyers by any chance and RPs, then you should log into, these NCLT proceedings. And
Yes,
at times, so many interesting things happens there. You feel
yes.
like, oh, what are we doing? But people have their opinion, and it will keep happening like that. So we'll keep learning slowly. But now, just to conclude this part of it, uh, any debt which is not fully serviced, but if it is above 1 crore and within limitation, it's not debarred. You can get it readmitted. Only thing is, please ensure that if you are representing the OC, then it should be mentioned. Better to mention it. At times, court says that, why to mention. Uh, in our view, we feel that, put that word cautiously, that we are doing it only for the sake of resolving the insolvency, not for anything else.
In your earlier example, what if it was not operational debt? If it was financial debt, still it will be different from contractual debt.
Ma'am, in my earlier opinion also, I did not agree to that. So this was Honorable NCLT's judgment that it is a contractual debt. So in my view, color of the debt will not change. Right? It starts from how it was originated. So it's like okay, there is a very good example what you asked me. A person can be FC as well as an OC. Is that possible?
In many cases,
It's possible, right?
Yes.
Sir, you may have provided services and you may have provided debt also. So you may be a financial creditor as well as operation creditor. Same goes for the bank also. A bank may be financial creditor as well as they might have given some service also. Especially financial creditor, maybe, bank is too much to imagine here. A person may be financial, maybe OC. He will vote in the COC only to the extent of his
FC.
financial debt. Same way, if you assign your debt to someone, what happens? It doesn't change the color, right? It only changes if it was FC, it will remain FC. If it was OC, it will remain OC. How can OC getting into contract will make it a contractual debt? Same way, FC debt also into contract will not make it a contractual debt.
Thank you.
can now one situation. This was operational debt, and this contract was made, and now this contract says that if there was delay in payment, then certain percentage interest shall be given, and this interest is different from the interest rate given on the invoices. In general case, invoice after 35 days or 45 days, 18% interest will be charged. Now in this contract, while withdrawing, it's about 12%. what will be situation now? Color will change or not? Just thought of mine only, not any big movement purpose.
No, sir. Definitely, sir. Any contract between two party, it is a contractual thing. It has to be honored.
Yes.
Time and again, Supreme Court has clarified so many times. If two people are agreeing on something, who are we to interfere? Until unless it is so exorbitant. Let's say he agrees on 200% interest. Now that is ridiculous, right?
Mm-hmm. Yes.
Let's say you had a gun on his head, you agree him on 56% interest. Now that is too much. So if reasonable debt, yes. Your question was whether now in the next time when we go for the reinstatement, on which part should we rely upon? Should we rely upon the earlier 12% or the 24%? Correct?
Yes. Yes. Yes.
Okay. Now here there is something called commercial wisdom of you and your advocate will come into picture, sir. See, your earlier application was already heard of, decided, agreed, argued, everything was done. Correct?
Yes.
Why you want to open the Pandora box again and reinstate and then prove this and get into that spiral again? Better you get it admitted on that earlier one because NCLTs does not decide on percentages. They only decide 1 crore plus, that's all. Default 1
Yes.
crore done. They are not concerned. Who is concerned is the RP.
Yes.
You go to the RP with that. For admission, don't worry about which one I should worry about. For admission, always go for the initial one because that was already heard. Somebody has taken decision. There is precedent. It will get admitted like flash.
Yes. Okay.
At the time of RP, go for that, increased one that, now this is applicable. Fine. Okay. I will continue with our slides then. In the case of Swiss Ribbons Private Limited versus Union of India, where the COC is not yet considered. See, it's an old matter, so now those things have changed a bit also. But in this was the first case where COC is not yet constituted. A party can approach the NCLT and the tribunal wide its inherent power under Rule 11 and may allow or disallow an application for withdrawal or settlement. Regulation 30A. So this is one rule which is general rule. Okay. Rule 11. Rule 11 is like those overarching power. If it is not written anywhere else, you come under this. Right? 143 of Supreme Court, 226 of High Court. So that way, section 60/5 and rule 11 of NCLT rules. Overarching power. If it is not written anywhere else, come under these rules. Sorry. Regulation 30A of IBBI regulation was amended to allow the consideration of applications for withdrawal of CIRP even before the formation of COC. It was clarified that Regulation 30 does not conflict with 12A, rather it complements the provisions introduced by 12B. So, Regulation 30, anyone knows what is Regulation 30? Sorry, 30A it should be. So, people used to say that 30A says after constitution, you can take 90% or this and that. So, court said that having 90% does not mean that if it is happening before COC, it cannot be done. So, this judgment actually introduced a concept called 12A can be done at any stage of the process. Any stage. Literally any stage. So only the resolution plan is under consideration. That is the only twilight zone. But otherwise, at most any of the stage they allow it. Here they said the other creditors of the CD will retain their independent rights against the CD, which would remain unaffected even if the settlement between the CD is accepted and proceedings are allowed to be withdrawn. Obviously. Further, Supreme Court has not only addressed the existing gap in Section 12A by affirming the IBC proceeding can be withdrawn prior to constitution of CRP, even if the CRP is initiated, but it also recognized the obligatory status of Regulation 30A. So it's technical, I don't think you need it, but 12A, read with 30A. This is our primary weapon for closure of this CIR. Withdrawal of CRP, I think we have learned this. Just in the matter of Abhishek versus Hukam, I mean, I don't know whether you'll remember it or not, but in this matter, it allowed the appeal and made the following observation. 12A does not explicitly prohibit the consideration for withdrawal before the constitution of COC. Despite being subordinate nature to the IBC, what is subordinate? Regulation. So code is always on the top. So sections, act is top, then comes regulation. So regulation is subordinate, but even though it is subordinate, it carries binding authority over the NCLT. See, NCLTs are normally bounded only by the act, not by the regulations. But here it says no, it is binding. It has a binding authority over to the NCLT. This interpretation is devolved in accordance with the regulation 30A, and the same is also in cognizance. I don't think this is important. Now, so that was prior to CIRP, post CIRP. Now, IBC originally enacted did not permit withdrawal of insolvency proceedings once admitted by the AA. But in Swiss Ribbon case, Supreme Court held that Regulation 30A1 is not mandatory, only directory. In exceptional cases, an application for withdrawal may be allowed even after the issuance of invitation of expression of interest, even if it was done. This ruling was reaffirmed in Brilliant Alloys also, where Supreme Court clarified that the expression shall should be read as may, making the provision only direct. So withdrawal when resolution plan is pending, then what happens? Suppose the resolution plan is pending now. It is submitted also. They only have to put a stamp on it. Then what? When the committee of creditors has approved the resolution plan with required votes and it is pending before AA for approval, and now the parties have arrived to a settlement and now they want to withdraw. In such case, after obtaining 90% of the votes of the committee of creditors, AA may approve such application. In Satyanarayan Mallu versus SBM Paper Mills, NCLT Mumbai permitted withdrawal of CIRP at the stage when resolution plan was pending for approval after acceptance by COC. The bench took into account the offer of OTS and made the corporate debtor, which was more economical than the resolution plan. Now, any one of you think this is fair? Or any one of you think this is unfair? Obviously, there can be only two views, right? Who thinks this is fair? Allowing a withdrawal even when the resolution plan was approved by the COC and now it is
I say
pending
it is
for.
fair.
You
I say
think
it
it
is
is
fair.
fair, sir? Okay.
So,
I will come to you, sir, why it is fair, but let's see
okay.
if anybody thinks it is unfair. Okay, everybody thinks it's fair. Nice. So why you think, sir, it is fair?
When resolution plan is there, so it is natural that if the COC is agree with this 12A, here they
No.
are getting more than the amount we are receiving
Yes.
in this resolution plan, and more financial viability in the with 12A. rather than this resolution plan, then they have approve it, and same logic will apply.
But sir, what about the resolution applicant? They have spent money, they invested time, they bidded for it, they were approved also. They must have started arranging for manpower to execute. Do you
We
think it's
cannot
fair for them?
keep happy every person, na? But main person,
But sir,
main
sir,
purpose is
tell me, you have invited, you put it in the newspaper. If he was so good, this person, why they did not do it 6 months in earlier? How can they do it at this stage? Do you agree?
might be earlier he could not have arranged the fund, and generally could not arrange the fund.
Okay. Okay. So obviously, sir, it was allowed. So we know that it is accepted. In fairity, I feel at times it's not it is little unfair, sir.
It
Because
may be
see,
depend upon case to case, sir.
yes, yes,
I agree that in
um,
sometimes it may be, and it is always unfair to the RA. It might always, but it depends upon case to case basis. Sometimes it may be unfair even to CD. In future, it may not work with the same promoter. So,
sir, why I
but
agree on this part is because resolution plan is approved by 66% votes. Correct. We don't know whether the plan was approved by 67% only, let's say. But 12A can only be done by 90%, right? Minimum 90%.
yes,
That means at least 90% are happy.
yes,
In resolution plan, only 66% were happy. Or maybe more. I'm saying different. But in resolution
it,
plan, there is a possibility that 34% were not in favor, right? 33.9.
yes.
So, going with that premise, I tend to agree with Honorable A's decisions. But in my view, at times, RA feels that, why we worked. Because sir, when you're buying a distressed company, I know you're trying to buy it at a discount, but you do put efforts, right? Otherwise, then nobody will, when they don't know till what date it is final. So, fair enough. Will we accept this view, sir? If everybody also think that it is fair, it is fair, sir. Okay, so we have learned this. Honorable SC, in these two, this case we just learned, right? Brilliant alloys that 12A contain no time stipulation allowed. Amit Katyal versus this matter I'm still handling. Amit Katyal versus Meera Ahuja. I'm a RP in this matter. It's a real estate company. Here, section 12A and regulation 30A are held to be directory depending on the facts of the case. In the larger interest of home buyers and under power exercised under Article 142, withdrawal of CIRP was allowed even after constitution of the COC. Now, having said that, Supreme Court allowed this withdrawal. It was finished. CIRP was concluded and the management was handed over back to Mr. Amit Katyal. Amit Katyal is the same guy who was in job for land scam case. He was involved with Mr. Lalu Prasad and all. So they run a company by the name Krish Developer. So now I'm RP in that matter again. How? That means when these kind of settlement happens, there is a fair possibility that it might can come back again. It doesn't mean that once it is over, it will never be started back. It can start any time. So they were able to withdraw it after constitution of COC, but within I think it took 1.5 years just to get readmitted into the CIRP. Now it is again running into the CIRP process. In another case, we can discuss in this case, I'm not putting the name because I don't think you will ever remember the name of the cases. So whenever it will require, we can remember the case. What happened in this case is, in view of section 12A, even during the liquidation period, if any person not barred under section 29A, you know what is 29A, right? Ineligibility of the promoter to put a resolution plan, right? Which is related party, not MSME, all that. I hope you have learned it, so I'm not getting into that. So you're aware, right? 29A is that
Yes, yes.
ineligibility criteria, right? Okay. So not barred under 29A, if they satisfy the demand of the COC, then such person may move before the AA by giving offer which may be considered by the COC. And if 90% voting share of the COC accepts the offer and decide for withdrawal of the application filed under 7, the observation as made above or the order of liquidation passed by the AA will not come in the way of AA to pass appropriate order. Both the appeals dismissed with aforesaid observation. So now with this Navanima, we have an option that even if it is liquidation, you can go for withdrawal. And same sections will be applied. I'll show you one of the order, such related order in the matter, like this one. And this was in NCLT Delhi 7/7/2022. This is how the normally the orders of withdrawal looks like. It says this is an application under section 12A of the code, read with 30A, read with section 65, also read with rule 11. So everything they have put into this. So 12A, 30A, 65 and rule 11 for withdrawal of the application admitted for CIRP along with affidavit. We heard the submission of the liquidator, of the counsel of the liquidator as well as the liquidator, and also noted the contents. Applicant has prayed for condonation of delays in the submission of the present application. The delay in filing is condoned. Applicant has also prayed for allowing the instant application in terms of averments made in form FA, having considered the facts and circumstances and in the best interest of justice, they allow it. And it has now become infructuous in way of accepting the present application, bailable warrants issued. So why I'm showing this order is, so we know that the order has come and they withdraw it, we allow it. But what happens after they allow it? They say once it is allowed, all these IAs have now become infructuous in view of accepting the present application. Bailable warrants issued under the respondent against the respondent are hereby recalled. Corporate debtor is discharged from liquidation. Liquidator is also discharged from his duties and responsibilities. Liquidator may inform all concerned apartments. Matter is disposed of. Case folders and connected papers may be consigned to record room. PNB is directed to comply with the communication, with its communication to the liquidator regarding settlement of his fees and expenses, including the CIRP cost. This was closed. Now, in this case, with this order, I had a little problem. In this
See, what is
order,
the bailable warrant?
okay, yes. Bailable warrant is a criminal charge. Because this was, so there were two applications filed under this. One was 19-2, which is non-cooperation, and another one was 66. So, some bailable warrants were actually issued in 19-2, where they were not cooperating. Imagine on one side, they are not cooperating with the RP, liquidator, and on the other side, they are coming for 12A. And there is an application under 66 which is pending. And 66 is fraudulent transactions. So when there are fraudulent transactions which are pending, it is still allowed. So it happens. Anybody has any view on this?
Sir, what about the application filed for the fraudulent transactions?
Sir, it says no. They have now become infructuous. This one.
ये तो
And
डंडा खा
becoming
लिया ना सीधे
infructuous
सीधे.
means they are of no use. They can be thrown out.
They are walked away.
Exactly. And they were heard and resolved by the same bench.
हाँ वो तो naturally it is in the same bench
No, no, no,
only.
no, 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 sir. It's not
You
naturally.
say same constituent.
Yes, same judge. And they were not open. They were not under consideration. Order was already reserved. There is a big difference. I hope you have that much legal understanding that order
Sir, the
reserve
company
is
is
different
different
than.
and the company is different and the promoter is different.
No,
And
no,
when
sir.
he is doing
Company.
fraud,
No,
he
sir,
is
this
cheating
is
the company.
Okay. Correct.
He
Company
is
is
cheating the
separate, is a
company, he is
separate
cheating
legal
the
entity.
shareholders.
Correct. Absolutely. But even that happens, sir. It's right in front of you. I'm showing you. So it's how you present your case, how you, get to the court, how you know. I'll show you another case. Recently, 12th June, I have filed. I am the RP in this. Devvart Rana RP in person. This was under section 9. You may read application as so another order, which is simple one, which is before withdrawal. So before COC constitution and before even publication of newspaper, what they write is application has been filed seeking withdrawal, wherein CIRP was initiated on so and so. It is stated that parties have entered into settlement day agreement, so and so. Applicant seeks to withdraw the present application. Having regard to the fact and circumstances of the application is permitted, IRP is discharged from the duties, and CD is restored back to the director. This is normally which happens within 1 day, 2 day. Whenever there are long durations, right? In that case, what happens is then you have to come to this. A Form A looks like this. If anybody has not filed it, I'm just showing it here on the screen. I hope you can see. I'll increase the font size. This is normally the Form A, application for withdrawal of insolvency under Regulation 30A, and all that format is already mentioned. To the A through Mr. So-and-so, RP of Sikkim Hydropower Ventures Limited, withdrawal of application admitted for CIRP of this company. I, Managing Director of AFRI India, I have filed an application bearing IB so-and-so. The said application was admitted by the AA on 30th 7/2020. AFRI hereby withdraws the application bearing so-and-so filed before the AA. The bank guarantee as per sub-regulation is hereby attached and they will sign it too. This is happening when? So the application was filed in 2018, right? And the withdrawal they filed in 2021. 3 years. Before this, I had already filed liquidation. You can read here. Mr. Rana in person. This is an application filed by RP under section 33 seeking liquidation of the CD. Let the copy be filed to the ex-director. Now, this was an era when RP was continuing as liquidator. Okay. Now we know that era has changed, right? Now, same RP does not continue as liquidator. Cannot continue as liquidator somehow. And This was the order they normally give in such cases, that the present application under section 12A moved on behalf of RP, stating that the matter has been settled. Same has also been endorsed by the learned counsel. It is being stated that COC has approved it by 98.54% vote. Thus, the petition should be withdrawn in view of the settlement. Taken into consideration the above fact, RP has stated that all dues have been cleared, fees have been paid, present application stands allowed. So till you say yes to it, it will not be allowed. So ensure as an RP, if you are there, ensure your fees is already paid, because otherwise it will not be paid ever. So please ensure it is paid upfront, then only you file this, otherwise you'll keep running from port to post. Under section 12A of the code stands allowed. This terminates, RP stand discharge, ex management shall be entitled to take up the management. CIRP proceeding cell stands terminated. So these are some of the orders I wanted to share. I guess we learned it. Okay. I hope I'm not going too fast or too slow. Anybody want to change the pace?
No, you are in good, correct speed. No fast,
I'm
no.
fine.
And
Thank you.
you are taking good time also. Otherwise, you said that in 15 minutes you can finish this. But
No,
thankfully,
sir,
it is
in
1.5
this
hours.
case, sir, in this case, thanks to you, because if you do not participate, I would have to finish it in 1 hour. So you are participating. I hope you are learning also in that process, because unless we discuss, we don't learn, right? Otherwise, it's a one-way traffic which would have come and would have gone. So thanks, you are interacting, sir. Okay. Now we'll move on, sir. Next slide. Applicability of section 29A. I hope it's not a repeat. In the matter of Shweta Vishwanath Shirke versus COC. In the present case, CIRP was initiated pursuant to an application filed under section 7 by Andhra Bank. Application under section 12A was approved by COC having more than 90%. Therefore, it was not open to the AA to reject the same on the ground of ineligibility. Okay. So we have been discussing that there is a word of may, right? Not shall. So the code says AA may approve, correct?
Yes.
But in this case, it was held that AA, it is not open to the AA to reject the same on the ground of ineligibility under section 29A. So they say here also commercial wisdom of COC, if they think it should be withdrawn, the court should not
Yes.
say no to it. Why they need to get into it? Because end of the day, it is their money. It is the money of the COC. If they want to withdraw it, why not? Let them withdraw it. Fine. And see, rest of those 10%, if they are not agreeing, suppose rest of the 10%, if they're not agreeing, nobody stops them from coming under section 7 or 9, right?
Yes.
So let them come under section 7 again. But this process which was initiated will be withdrawn. It was held that 29A is not applicable for considering an application under 12A, as the nature of both applications are not different and the applicants are not entitled to file application under 29. So that may is also please consider as shall only, because that also people. So A has literally no say wherever COC has said yes. Until unless it's right on the face of it, it is wrong. So let's say it was a 1,000 crore company and they said, okay, you pay us 1 lakh and we agree. So maybe that kind of situation, they can entertain. Otherwise, nobody will check into it. In this matter, I'll share the PPT. You can save if you need it for future purpose. Honorable Supreme Court held that the interference would be warranted only when the A or the appellate authority finds the decision of COC to be wholly capricious, arbitrary, irrational, and dehors the provisions of the statutes. That means it's completely something bizarre. Then only it should be looked into it. Otherwise, don't look into it. Whatever they have decided, just go with it. When 90% or more of the creditor, in their wisdom, after all due deliberations, find that it will be in the interest of all the stakeholders to permit settlement and withdraw CIRP, in our view, the A or the appellant authority cannot sit in an appeal over the commercial wisdom of COC. Honorable HC further held that the interference would be warranted only when the AA or the appellate finds the decision. This we have read. However, we do take this opportunity to offer a note of caution to NCLT LAT functioning as so and so under IBC from judicially interfering in the framework envisaged under the IBC. Consequently, the need for judicial intervention or innovation from NCLT and CLAT should be kept at bare minimum and should not disturb the foundational principles of IBC. Now, can anybody would say what there's an amazing innovation, judicial innovation, which is going on in real estate CIRP matters from NCLAT. Anyone would like to say what is that? Which is not there in the code.
Reverse CIRP.
आप बहुत जल्दी आंसर दे देते हो सर.
आगे चुप रहूंगा. अभी चाय की कॉफी ले लेते सर.
No. I just wanted to sip a glass. That's absolutely right, sir. Reverse CIRP. There is no such thing in our code as reverse CIRP. And reverse CIRP is going on in so many cases. Reverse CIRP. Anyone knows what is reverse CIRP? Other than sir?
No, sir.
Nobody?
No, I at least know. Kindly.
Sir, can you please enlighten us a little bit?
I have no clear idea. So, but
What
what
do
I
you know?
understand that if there are more than one project in one particular CIRP, then your CIRP is break into many, and all projects come under the different CIRP. But I have no practical idea.
No, sir. That is called project-wise CIRP.
Project wise. That is project wise. Yeah.
That is not
Reverse CIRP.
reverse CIRP.
So I have no idea.
Please elaborate. And
The real CIRP is a concept where, so it is CIRP, but COC may or may not be there. Promoters are still in the control. In that control means RP is there, who is managing the show, but he is getting the construction done from the developer itself.
okay.
So they are still finishing the project. No external force is coming into play. Interest part is not into play, but they are finishing the project. The erstwhile management.
Under supervision of RP.
ARP or RP, yes. So
Okay.
if it is stayed, if it was RP, then it will remain RP.
Certainly,
If it was
certainly.
IRP, then it will
Yes,
be
yes,
IRP.
obviously.
So
Yes,
continue
yes,
as IRP.
Yes.
So supervision of RP, funds
Yes.
will also be under the supervision of RP. Everything will be under him.
Yes.
But he is executing the project, the developer himself.
Yes. It happens. Obviously.
He's saying, okay, what rate we can sell it, you can sell it. So he's taking all the shots. Only thing is you are like an observer, the person who is, so just a sec, I'll close my phone. Yes. So that is reverse CIRP. Now there is no concept of reverse CIRP in our code,
Yes, yes.
right? And it has
Right.
not been challenged also. That is a nice part of it.
And in normal CIRP also, your management is under your control, RP control,
No,
and he can do
sir.
everything.
Sir.
So what kind of a
Absolutely.
different? It is not clear to me.
Perfect. Good question, sir. So now what happens is in reverse CIRP, I will not publish Form G. I don't need to make Form IM, Information Memorandum. I don't need to invite resolution plans. I don't need to do all those things.
Okay.
There is no CIRP actually going on.
So it is a simple business under RP supervision, and just monetary benefits are there. RP supervision and NCLT supervision is there. And when project complete, then all money will come after sale, and this will be dispersed among creditors and others. And
Absolutely.
everything is normal. So it is back to normal.
Absolutely, sir.
So
Okay.
when sir it is CIRP, and since bank would be not be there, only class creditors would be there. So will they not be considered as a part of COC also, or COC meetings are taking place?
COC meetings are there, no doubt. But COC, okay, depends on whether COC meetings are also allowed in that or not. At times,
Yeah.
in fact, I think my partner was also here online. So here in one of the COC, we only have to report to the NCLT. A quarterly report has to be sent. That's all. Nothing else. So you don't have to do any, monthly COCs and quarterly COCs and take approval of this and that.
So this 330 days period will be there or not?
No, sir, nothing.
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 Means
So we are
like
doing today's
liquidation what we used to have.
CIRP. We are in our company. We are also doing Gayatri CIRP. They are all into reverse. Ajnara we are doing, like one of my partner is doing. So they are all under reverse CIRP.
A
In the
similar thing I am doing
wherever
in
home
one.
buyers are there, courts are more than inclined to go this path. Now this path is
Exactly.
nowhere there. It was invented by NCLAT. And it is not being challenged. My worry is why it is not challenged. I'm not saying it doesn't have benefits. Everything
no,
has benefits.
If it is
one plus
challenged,
in
then a home buyer's interest will be held, and then it will create problem for government and
that is
almost all stakeholders.
Sir, we go to Supreme Court for even my buffalo is lost. So why people are not going for this? I still fail to understand.
No, sir. In this case, the buffalo, that is the flats are uh, being given birth very soon, hopefully very soon. Then that's why they are not appealed.
Sir, in a liquidation case, I am handling the similar things because liquidation is there, and during liquidation, some of the flat owners who has got possession for incomplete work, they filed IA with NCLT, and other part promoters or some other, and they have made an association of persons and given some proposal that this amount is required. On the other hand, since some of the registries has not been made, so I have some amount recoverable from there. So they have taken a responsibility, and NCLT told that you go and mutually agreed. We place the matter before STC, and with some amount of advance, STC approved the proposal. Okay, go ahead. So for that, to complete the project. So where though I am as a liquidator, but now I am supervising the things as a completion of that project. A similar way like it is there during CRP, I am doing in liquidation.
Sir, as you rightly said, in home buyer's case, there is no such thing called liquidation.
Exactly.
Because you are not going to bring the tower down, right?
Not at all.
Unless nothing is there. Let's say there is nothing, right? Only land is there.
Yes,
But if let's say some people are staying in the CIRP, I am handling real estate. There are 176 people. I have already done 63 registries.
Yes.
109 possessions I have given. Rest of the one, if my 270 days are over, do you think we'll go into liquidation?
Not
Or
at all.
even if we go into liquidation, what is going to happen? So
And
court also
in that
understand
case,
this and
yes,
yes.
in case of liquidation event, because some other portion of the property, whatever complete is there, financial creditors has taken a multiple mortgages used to be there, not a consortium
Correct.
type. So everybody has
Correct.
taken their part, pie, and rest remain with us in complete project. So which I am completing during liquidation.
And that you're completing now from pool and build kind of mechanism,
Exactly,
right?
exactly. Yeah, association of person, they have been giving money. So initially we have taken some sort of advance so that at any time of any sort of time, expenditure may not be more than the income. With the condition that as a liquidation means stakeholders will not bear anything. Everything has to be borne by the association of person. And then I will agree to do the registry, etc. So on one hand, I am doing registry and getting income means unpaid money from the flat owners. On the other hand, same money is being applied in completion of the same project.
Perfect. Perfect. So again, I use one word called pool and build. So just for our listeners here, pool and build is a mechanism where home buyers, they come and they pool their money. They said whatever has happened, if anything was due, they will pay. If even that is not sufficient, they will say, okay, we are ready to put another 2 lakh, 5 lakh, 10 lakh. Like in my matter, we
Yes.
are taking another 20 lakhs from each, because these are 7 crore apartment, minimum size is 6,000. So they said we are all ready to put another 20 lakhs. You will have 34 crores in the account. You finish the project. But they did not want to give it to the promoter. They said they have already done, whatever they wanted to do. Now let RP be there. Let him finish this project. Now, how the RP will be there? Now, RP will be there only when there is CIRP. If there is CIRP, RP will have to invite claim, do this, that, all those things you need to do, right? Now, if you need to do all those things, are you doing those things? No. Now, since
No,
you're not doing any of these things, it is called reverse CIRP.
reverse.
That's all,
Okay, okay, okay.
right?
Okay,
And
okay,
in
well,
this only, it is, we use this word term also called pool and
cool.
build.
Built, built. Very well.
Pool and build also we use in this concept.
Very well. Very well.
Yeah. So this is another exit strategy from the CIRP.
Exactly.
So developers, at times they may file on section 10.
Mhm.
You know why they will file section 10? They will file section
Okay,
10
okay.
because they don't want to pay to Ghaziabad Development
Exactly.
Authority and
Development
Noida
authority also.
Development Authority. And Cloud9 could save 670 crores just
Certainly.
of GDA. Or maybe let's say you don't want to pay EDC, IDC in Gurgaon.
Mm.
You go into this, don't pay them. So there are a lot of innovations which goes
Innovations are
on
there.
the on behind of things. So everything
IBC.
we generally don't discuss in a webinar, but
Exactly.
there are smart peoples working behind the scenes also. So yes, that also happens. Okay, next one is exit during liquidation. That's what we just learned from one of our sir.
Sir,
Sir,
I
your
think we
name?
should take a 10-minute coffee break. You
I
are
have
okay
I
with
have
all
ra-
others, my
I have
all
raised
other.
my glass, sir. I have raised my glass. I certainly accept that. Let's join at 4:15 if that sounds good.
Okay.
Anjali
Okay,
ji
okay,
will take
okay.
a break of around 15 minutes. I don't know
Okay.
what
Yes,
time it
sir.
is.
Yes, sir.
3:54. So 4:10 is fine. 4:10
Yes,
we
sir.
will
Yes.
Okay.
Yes, sir.
Yes.
reassemble and
Okay. 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 Okay.
perfect. Thank you, ji. Thank you. Good.
Thank you.
We are back.
Participants, shall we start now?
Yes, I'm here.
Yes.
Okay. Fine. Let's get back to our. I'll show my screen. Fine. So we'll now again go back to our exit during liquidation. Now, standard liquidation process provides for sale of assets, distribution of resolution, and putting the shell to rest. Fine. Shell means the company is now put to rest. The story is finished. Now, I think that is also, if we go by the topic itself, can we call it exit from CIRP, going into liquidation? Going into liquidation is also an exit from CIRP, isn't it? Suppose there is a CIRP which is so, onerous. Onerous means running the CIRP will cost more than what you would have recovered from it. In that case, what do? You go for, liquidation. That is also an exit strategy.
But
Because
we
suppose
can
there
go for direct dissolution also.
a direct dissolution is not possible, man.
Okay.
Direct dissolution is
If there
not.
are no assets, actually.
Then I would like to show you something. Good, you have questioned, and let me show you one order here. Again, one of my personal order. I'll show you, which says this one. This is. My screen is visible.
Yes.
Okay. Now, this was a matter, again in Delhi NCLT, section 33. Somebody filed it, went to somebody, blah, 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 application filed by. Now I told you, as I told you, now that era has changed where RP will continue as a liquidator, right? So NCLTs, they will always replace you. If you are an RP and the company goes into liquidation, they will straight away take you out and send you somebody else, right? If a new person is proposed, it's fine. If not proposed, then from the panel they will pick it up. So this gentleman, Mr. Rakesh Verma, he was RP. Here they said, Rule 11, blah, blah. What I want to show is brief background, okay? So one matter started, Alok Kumar Agarwal ji was IRP. Then we appointed a new person. Form A was published to call upon creditors, newspaper, also everything was done. EOI was published, so and so date was there. 99 of the COC member with 99.89%, okay? It's like almost 100%, right? This member suggested to proceed with the filing of liquidation application, right? Accordingly, the third COC was conducted. So imagine in the second COC itself, they are proposing. Why they are proposing this? Because obviously they know there is nothing in the CD, right? Accordingly, the third COC meeting was held, wherein the agenda regarding liquidation was deliberated as per the section 33(2). Now, RP apprised the member that the CD has not been operational since 2018-19. Books of CD shows no fixed assets apart from financial assets, which do not bear much realizable. And this much is how much? Much is 71 rupees. Accordingly, the resolution to proceed with filing of liquidation application was put to vote. Look at the order. The funny part is the order. This. Okay. I'll straight away come to the order. Okay. So total loans at advance, this is owned by one person and there was some security. Okay. Corporate debtor has no assets has only assets in the category of security and financial assets and no movable assets. So that is zero. Movable is zero, office is zero, nothing. Here, I want to show you what they write it and still they send it for liquidation. Why? Member of the COC are the best judges of their interest, fully conversant with market trend. Therefore, their decision should not be interfered. It is not part of the judicial function to examine their commercial. We are of the considered view that there is no chance of receiving any resolution plan. CD does not have any asset or property, and the CD has not been operational since 2018-19. Book of the CD does not show fixed assets from financial asset, having no realizable value. Hence, RP moved an application seeking liquidation. Hence, in the circumstances, we filed by so and so. So they appoint the new person. Mr. Rana is appointed, blah, 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 blah. Okay. RP shall file his authorization. He will be relieved, etc. Now tell me, if the court knows everything, that there is no realizable asset, nothing, why they can't straight away go for liquidation, dissolution?
They will only
What is-
say ki what is in the prayer, accordingly we will order. If
No,
we have
no.
directly say that we want to dissolve it because there is nothing to
Okay. Section 33, ma'am, please, if you read ever, where does it say that you can file for dissolution?
No, it does not say, but whether it is
If you
possible.
cannot
because,
say, no, it's not possible.
Going for
That is why
liquidation
I'm-
again, there will be minimum 1 lakh to kharcha aega.
Ma'am, if
that nothing is there.
Maha Mahims are not doing it, how will an RP will do it? Tell me.
Okay.
You can't even ask, because if you'll ask, then this prayer is wrong. This prayer is wrong because this does not allow. Now, under section 60/5, they could have done it, right? Now, I am running this for last 5 months, 4 months now. Just to close one bank account is taking a lot of time. So that is a problem. Now, who will bear this 4 months cost?
Oh, that is
Nobody. They have not even paid the CIRP cost. So, commercial wisdom says it should go to dissolution straight away, story is over, right? But that option is not there. So, exit from CIRP is only liquidation, and then only it can go to your further dissolution. Now, I will be filing an application for dissolution.
Achha.
RP could not file that.
Okay. Thank you.
And as you rightly said, we could have asked in the prayer. Maybe that has not been explored by anybody yet. Maybe what consequences it might have. Let's say, who will close the bank account if the company is dissolved?
If it is already, first we have to close it and then submit the documents that we have already closed the bank account. And then
No,
wait
that
for
is
the
what I'm
order.
saying. So direct dissolution. Okay, you are saying in CIRP itself, I should have closed it. That person should have closed it, and then go for filing of. Okay, so that has not been explored, and I don't know if anyone here present has ever seen any such situation. Would like to share?
Yes,
I
sir,
have made
I have
an
seen that.
application.
Okay.
Sorry,
I
ma'am,
have made
carry
an
on.
application. But it is still pending. That is why I can't say right
So
now.
Vaishali ji, in which section you filed it? Under same 33.
Let me one minute. Let me check it. I will
Okay,
check.
okay. And Sunil ji, what did you do? Which
Sir, I
one?
saw the order also, but I don't remember it and I don't have on my laptop also. And even the State Bank financial creditor told me that yes, it happened for one of the company. In Kolkata, I am sure it has happened. Direct from CRP to dissolution.
In Kolkata, they have allowed
Yes, sir,
such
but I
application
don't.
where
I remember having seen that also.
I will file that, sir. Will certainly find. Though I was not the RP, I'm not
Yes.
saying that I had an option. I explored and did that. I was
Because
only appointed from the
I
panel,
am
so
appointed as liquidator of one of their group companies, which has one of the CD who has many group companies, one of the person. So at that time, he also told me that that time we did not go for direct dissolution. So nowadays the court is giving. He also told me. Then I searched it also. So I saw. I don't remember the name right now.
that's okay,
Maybe
sir.
I will.
If you could search, we can all search, but it's good
Yes.
to know because in my view, there was no option. But as you said, under section 60/5 rule 11, anything can happen. So if there was no asset, this person should have explored. We will also explore, and I'm sure all RP sitting here will also. If there is nothing, what is the fun of putting into, or maybe this person thought that uh, there is no reason of him because he is not going continuing any which ways. So even if it is going to somebody, it's fine. But I think as a RP fraternity, we should think about it. If there is a possibility of direct dissolution, we should. I will certainly look at that option, sir. And we agree on all. Vaishali ji also, I think, might have found what she was looking for.
I have got that order. It says Novel Advisory Services Private Limited. NOUVELLE.
NOVE
NOUV.
UV. Okay. Double LE.
Yes. Advisory Services Private Limited.
Perfect, sir. Thank you for sharing. We will look into this. Services privately. Okay, so this is another way of exiting CIRP. I think we can add into our slides. Then only I'll share that. As you have mentioned, from CIRP, we can go to liquidation, one strategy. Go for direct dissolution also. That is also possible, uh, as was held in Novel Advisory. Now, okay, there's something called Regulation 39BA. 39BA is another way of, exiting the CIRP. What is that? That is assessment of compromise or arrangement. Now, this regulation says while deciding to liquidate the CD under Section 33, the committee shall examine whether to explore compromise or arrangement as referred in this regulation, as referred to Regulation 2B of the IBBI liquidation process, and the RP shall submit the committee's recommendation to the AA while filing the application. So, you tried to sell the company, you ran the entire CRP process, you thought a new person has not come into picture. And you also did not want to discuss with the promoter, let's say at that time, because maybe they were not available, they were not interested, or you were too high-handed, whatever the reason may be. Now, under 39BA, you have this option of assessment of compromise or arrangement. Where a recommendation is made under this regulation, the RP and the committee shall explore the possibility of compromise or arrangement during the period the application to liquidate is pending. So, during the period application to liquidate the CD is pending, even during this period. So see, after liquidation, you have 3 months period, right? To do what? To sell the company as a going concern. The liquidator can try that also. And you have a period which is from filing of application till acceptance of application. During this period also, you have 39BA where you can explore this compromise or arrangement. 39C says, 39C is the one which I was saying, assessment of sale as a going concern. While approving a resolution plan under Section 30 or deciding to liquidate, the committee may recommend the liquidator can explore sales of CD as a going concern for the first 3 months or 90 days. Where the committee recommends sale as a going concern, it shall identify and group the assets and liabilities which, according to its commercial decision, ought to be sold as a going concern. Now, anybody would like to tell what is the difference in selling as a going concern and selling as a piecemeal basis? Why we are still trying to sell as a going concern? Does it have advantage?
It revives the CD as it is.
How does
and
it matter?
Means the name of the company or licenses or whatever. Or
No, no.
no,
Okay.
yeah, that trademarks maybe they are even if there are no assets or something or still the
Correct.
company is will work as a going concern. And in case of piecemeal, only the assets are sold. Here the assets and the company are sold.
Fair enough. See, why we try to do something? We try to do something because it will have some added advantage only. Correct. Otherwise, why to take extra pain? You take extra pain only when in the other situation that benefit is not available. Now, a land will remain land. Correct. It will not go down the value whether it is going concern or liquidation. House will remain house. Everything else. But as ma'am said, if you have a license, if you have some intellectual property right, if you have some, let's say brand value, brand name, something which was under your umbrella, which will go dead the moment company is dead. And you feel that it may give you even, let's say 10 lakh rupees extra it's giving you from the entire episode, then why not explore it? Plus, there is a sense of reviving the company than liquidating the company. Liquidation means corporate death, right? So instead of corporate death, if we can revive somebody, that sense that okay, let's try to sell it as a going concern is beneficial. Only thing is, when you sell it as a going concern, the liabilities comes back, and that is why people used to earlier think that why not go into liquidation only. Earlier, let the company be dead, only the heart and lung and whatever is remaining in the body, let's remove that and use it. But now, luckily, after Section 32A, which is Ganga Nahao section, after that section, there is possibilities where people are buying the company as a going concern in the liquidation also. So now, earlier also, sorry. So in liquidation, if a company goes for, as a going concern, I personally don't know many cases where such things have happened. They only go for until unless it's a settlement kind of arrangement. Nobody buys the company in liquidation as a going concern. But yes, on theory, there is a possibility here. In this, the example which I was just showing you in Mangalam, I have found one person who is ready to take over the company in 1 lakh rupees. They are saying sell it as a going concern to us in liquidation. What advantage they can identify in that, I don't know. Maybe it's a public limited company and reinstating a public limited company with around 51 capital, paid up capital. Maybe that is one advantage. Maybe it's a 15-year-old company which somebody wants to take over because when they start the company, run it for some time, let's say slowly, after 3 years of balance sheet, then you will say, oh, my company is 14-year-old company, and now I'm coming for a, so maybe that legacy uh, thing, if somebody wants to use, if name is such nice name, somebody might like that. So that is also an added advantage. 39C is for that. It says you can assess whether you want to sell it as a going concern. In fact, what we have seen in our experience, many of the NCLTs now they are saying that RP should explore this option as a sell it as a going concern. Do not start liquidating on day one. Try for 3 months if it is possible. If not, then only you go for the liquidation. That is also happening. Any view on this? Anyone has? Or we are good to go? Okay, we'll move on then. Regulation 2B of liquidation regulations. In liquidation, so what we have discussed is now in liquidation regulation, compromise or arrangement. Where a compromise or arrangement is proposed under Section 230 of the Companies Act, it shall be completed within 90 days, provided that a person who is not eligible under or wherever 29A applies, it will not be applicable. Provided further that the liquidator shall file the proposal of compromise or arrangement only in cases where recommendation has been made by the committee under regulation so and so. And why they say so is because otherwise RP will ask for fees during this 3 months also. RP fees is allowed only till the date of filing of resolution plan. After that, it's COC's prerogative whether they want to pay, they don't want to pay. Our regulations, like that minimum fees of 1 lakh, 2 lakh, 3 lakh, that is applicable only till the date of filing of resolution resolution plan, if it has come. Or if not, then filing of the liquidation application. Fine.
So what happens when there are cases pending in the when RP has filed cases for recovery of some monies and is attending the court?
You are
And
appointed
for
any
3
such cases, sir?
months it takes.
You are
Yeah, I
appointed
did.
any
In my
such?
case, it happened.
You know the
Yeah,
answer,
in my
sir.
case, it happened.
You know the
I
answer,
didn't
right?
get money, sir, but I didn't get any money, but I did. I put a lot of efforts on that.
I know that, sir. That anybody else has similar experience? Because we all have this experience, where you filed it. In
My
one
view,
of
it
my
is not
matter, I
correct, sir.
filed. It is not
In my
correct.
view, it is not correct, sir. I just can I leave it there, then and there, not attending further proceedings of the cases where I have filed. No, I had to.
Now that is a problem. You cannot. So now they say the person is on the operation theater. You remember if any one of you are from like earlier days when we used to have that conference meetings with IPBI, we used to raise this. We said if you are not paying us for this period, why should we work for this period? They are saying no, the person is on the let's say death table, is on the in the operation theater. How can the doctor run away saying it's my Saturday, Sunday, my wife's birthday, or I'm not getting fees? How is it possible? How can you even think of it? Initially there was no option of RP resigning also. Initially in this code, there was no option of RP resigning. Now you have an option of RP resigning, right? So earlier they thought no RP will run away from this. This is such an amazing law. We will always continue doing it. We are only God sent persons. So we should keep on doing even if we are not paying. Sir, peace has nothing to do with our responsibilities. So your responsibilities will continue as is this. You cannot
But
miss
cost
on
also will be
those.
there, no, sir, for attending court, I had to travel and
That is a choice.
all from my pocket.
That is a
And I had to
choice, sir.
put some
We
efforts
have.
also. It is not I had to put time. for
No,
preparation
sir,
before
effort,
the.
time, and plus you cannot do everything, right? You will be taking help of other people also. Why will they work for free? They will say, it's your problem. You work for free. Why should we work for free? And you will have to pay them. So
Even
that
then,
and that is
sir, even then, judge asks many questions to the RP, and he asks, why, where is RP? And if suppose RP is not attending, then he will make a big question and it will be typed in the order itself.
that they type in the order and they direct the IBBI to take a call.
Yeah.
So
But it's not
those
correct, no, sir.
Shoko's notices, sir, we are living that life. I'm sure everybody is living that life. So we'll not crib on that part today at least. Today we are learning exiting from CIRP.
Sir,
So,
one
but yes,
small
that is
doubt,
an
sir.
yes,
Sir,
yes,
one
Mr.
small
Pana.
doubt. This minimum fees based on claim admission, whether
Yes.
that is applicable only during CARP or even liquidation also liquidator can quote that minimum fees based on claim admission.
No, sir, liquidator is not able to do that.
Okay.
Liquidator has its own schedule of payment.
Yes.
Correct?
Yes, sir.
They are saying you have your schedule, take it from the schedule. RP did not have schedule, so they fixed it up.
Okay, sir.
So since RP, same goes for in personal insolvency also. Huh? In bankruptcy, there is a schedule. You
Okay.
can use that. But in personal insolvency, RP does not have any fee structure. So there they say that, it's market driven, do it.
Okay.
There we don't even have minimum. People are even charging 5,000, 10,000, 15,000, 25,000 per month. So that is happening, sir. Unluckily, your answer is in negative, sir. Uh, we do not have anything fixed for the liquidator. Okay. So I think we have done this part. Shall file compromise provided further that liquidator shall not file such proposal after expiry of 30 days. Time taken on compromise shall not exceed 90 days. I mean, these are really not important. So only important thing you need to remember is that CIRP, you may go to liquidation. That is another exit. Even before going till liquidation, in between, there is a twilight, some time. That time you can try within, let's say, 90 days. And that is why at times we don't get liquidation order right, next day. That is being used for this twilight zone. If that is not possible, in liquidation also, first 3 months, you can try to sell the company as a going concern. Now, the regulation 32A of liquidation, what it says about sales as a going concern is where the COC has recommended sale as a going concern and liquidator is of the opinion that the sale under these clause will maximize the value, he can try that. I mean, this rest of the things doesn't have any meaning. They only says liabilities, assets, you have to identify, blah, blah, blah. I'll be sharing this. You can read it, but nothing to mug it up. No need to mug it up. Liquidator may sell the assets of the CD under Regulation 32 exclusively on at a at the first auction. So this can only happen on the first auction. Huh? Sale as a going concern, you say, I'm still trying, second try, third try, fifth try. No, that is not going to happen. You know why they say that this can happen only at the first auction? In my view, let me put my view. If somebody wants to add, you can add. I think in my view, it is only to dissuade some enthusiastic liquidator who has only one case in life and they want to keep on, running it and keep getting experience out of it. Other than that, I don't think this has any significance. I mean, whenever you can sell it, sell it. How does it matter? Somebody is ready to take it. People are ready with 90%. Earlier you had COC, now you have SCC. If they allow it, it should be allowed. But our regulation says that it can only be done in the first
No, sir,
at
it is the
any.
word is exclusively. So I think it means that in first option only it is exclusive, and
Yes,
then
yes, sir.
with break of assets also.
Yes, sir. So after that, you have to break it up. You cannot sell it as a going concern.
No, 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 sir. I think it is exclusive only at the first option means in second option you may give all the options. First as the going concern, then all assets separately. So whichever is maybe explored. I think so. So otherwise the meaning of the
Okay, okay,
exclusive is
okay,
not
okay,
there.
okay. Okay, fair
I
enough.
am
So
try
you,
to giving this meaning to the exclusively.
fair enough, sir.
It
Fair
is my
enough.
only
So,
opinion. Other
so I got your point, sir. So you are saying if this auction is happening within 90 days, then obviously we have to give this option. Because first 90 days, we have already decided to work on the sale as a going concern option only. But okay, you are saying that even if we are doing it after 5 months, if whenever we are doing the first auction, that first auction can only be as a going concern. And after that, we can keep it as a going concern plus as piecemeal also.
yes, it is my view only. A counter view may be there.
Anybody has any counter view? No, I tend to agree with you. I think you're right. So normally, okay, this is theoretically what you are saying is right. Theoretically, I mean, practically it won't happen. And by then you will not have any assets. Nobody is contributing to liquidator. And liquidator will be compelled to sell the things in a piecemeal basis. Uh, I'm assuming, let's say there are 2, 3 assets in the company. Whatever asset you can sell first, you will sell it. You will not wait for, anything else. Okay. Now this regulation 14 of early dissolution. Anytime after preparation of the preliminary report, if it appears to the liquidator that the realizable this is exiting from the not CIRP, but from everything. So early dissolution is actually, why we file early dissolution. We file early dissolution to let the RP go or the liquidator go, please. There is nothing remaining there. Let me
Sorry just for
also go.
interruption.
Yes.
Just after 32, this 32A, there is an
Yes.
explanation. It was recent.
Okay.
It was introduced in this February 24.
Okay.
This explanation read, for the purpose of this sub-regulation, it is hereby clarified that the sale of the corporate debtor under clause E of regulation 32 cannot be offered as the only option for bidders after first option. So it may not be the only option thereafter. So it may be one option thereafter. So it is written in this.
They have given in the explanation, right?
Yes, yes, yes. You are on this screen also. You have.
And you are saying where I have written it.
This explanation after clause 4.
For the purpose of sub-regulation, it is hereby clarified the sale of the CD under clause E cannot be offered as the only option. Okay. So
Only
after
option is the bold in term. It may be keep at underline for these words. So exclusively in the main sub-regulation 4 and this only option, these two words in this explanation may be underlined for the purpose of interpretation.
correct. It came on 12th February 2024.
Yes, sir. Yes,
It
sir.
came in
This
12th
year only.
February 2020. Yes, this year only, sir. So this year there are a lot of changes, and to be fair, we are, as
Yes.
many of the RPs, I think we are 24 people here. So RPs are more concerned about CIRPs. At the time of liquidation, we don't even read the regulations. We say things have gone, down the drain. Let it go down the drain. So in February, actually, this year, lot of changes have happened in the code. So if some of you have missed them out, read those also. February around 12th and 15th of February, a lot of these regulations and explanations were added into the code. So this also, sir, as you rightly said, 12th of February, this explanation was added into the picture. That first regulation cannot be offered as the only option for the first offer. So in explanation, they have clarified. Okay. Now, early dissolution, we said that preliminary report you have to file. If it appears to the liquidator that realizable properties are not enough and the affair does not require any further investigation like PUFE applications, etc. If those are not required, then you can straight away go for dissolution. He shall consult the consultation committee. Consultation committee is your SCC. And if it advises for early dissolution, he may apply along with a detailed report incorporating the views of the SCC to the AA for early dissolution of the CD. That's all. Oh, that's all. So that's all for the day. Any question we have? Otherwise, it was a nice session. Vaishali ji, you are now silent. Are you still here?
Sir, one question. This even PAFA application is pending, whether we can move for dissolution.
Yes, now that is a problem. So if PUFE application is pending, that means some investigation is still not completed. Correct? Here it says anytime, if you read it, the affairs of the CD do not require any further investigation. So if it does not require any further investigation, then only. See, dissolution is what? Liquidation is death of the body. But dissolution means putting fire on it. So once fire is put on, then nothing is remaining. Then you cannot identify postmortem. You can't do any such thing.
So, no, sir, with 32A, you cannot say liquidation as death. Now, liquidation is on the deathbed only. The dissolution is on death.
Okay, fair enough. So, okay, he's half dead kind of in liquidation. So, but early dissolution is dissolution is dissolution, sir. So dissolution is end. See, early dissolution sorry, I didn't get the last name who asked this. If PUFE is pending, this will not go through. Because then RP cannot say that the affairs of the CD do not require any further investigation. So either you have to stop pressing that PUFE, get it withdraw, get it dismissed, and then only file for dissolution.
But if such application is pending, liquidation period 1 year is about to over, then should
no other option but to extend it, sir. Extension, sir.
So until these application must have been settled, you should wait.
Have to wait, sir. Not should.
But we can file and NCLT will hang up it. Normally, all
Sir,
the
if
pending
PUFE, wait,
applications
wait. No, sir. If PUFE, suppose you get a favored order. Suppose PUFE says you will get 5,000 crores.
Yes.
Who will receive it? If you have already put the fire, the body is no more. Who will receive it?
I understand your point, but my small point is that we can file application for dissolution, but NCLT in normal course, in my opinion, firstly decide all other IA, then take this dissolution IA. So by doing this, we are not going for this continuous extension, and what happens otherwise every progress report they will ask, what were you doing? You are giving the same answer. The resolution
agree.
application stop your quarterly progress report, auditing, and so many other things. Once all these applications came in the favorable result, then this application for the resolution may be put in an abeyance. It is my opinion, my
Fair enough.
exploration
Fair
only.
enough, sir. Fair enough, sir.
I'm
So,
not sure whether it is happening or not.
Sir, our question first was whether we can go for early dissolution. So early dissolution, we don't have option, right? That 1 year period is there, right?
Yes,
After
agree on that.
after 1 year period, when we are going for normal dissolution, I also think, as you rightly said, we have filed for it. If you allow our, you know, PUFE application, we are getting any fund back, then this application may be discarded as infructuous, or if that is discarded, then this may be taken up. So only thing you need to do at the end of every month to IBBI is just inform them that application is filed and pending for adjudication, so that your work is over. You are saying that, right?
Yes, yes. That's
I somehow agree with you on this point also, sir, in my view.
I am
So,
only somehow agree with me. I am not completely agree with me.
sir, I'll tell you why we are not able to completely agree with you, because many a times, we got a case in Hyderabad NCLT, it was, where an application was filed by an RP saying, sir, either you allow me extension, or if you don't allow me extension, allow for liquidation. Is that wrong? See, if extension is not allowed, what is the next step?
Yes, simply liquidation.
Go for liquidation, isn't it? So what wrong did he do by saying this? In my view, nothing, right? He was just being little more vocal. That's all. And RP got actually, court was ready to pull this person up. What kind of applications are you filing in front of us? Either do this or do this. How can you do this? You put for one prayer, either this. If we allow both your prayers, then what? I said, sir, there is no both prayers, right? So I was not the RP, luckily, in that case. One friend was there. And this also happened. So why I'm not totally agreeing with you is depending on the circumstances of the case. That PUFE application is, whether it was a fraudulent one, what's the kind of, amount there. As we said, always it's case to case. We generalize, we cannot say, but somehow I tend to agree, sir. Instead of running it for years and years, we can go for only if PUFE is pending. But in my
Yes,
view, they will never allow it, sir. And you will have to continue to attend and
yes,
keep
yes.
filing your progress reports. So I guess if we have nothing to say much, then we'll close the session for the day. Anjali ji, are
Thank you,
you
sir.
here?
Very nice presentation, sir.
Uh,
Thank
Thank
you.
you, sir.
I learned a lot
Today
of
topic
new
was
things.
little different. I don't know whether you people have faced it or not. But if you have not, you will face it. 12 will certainly come in an RP's life. Every month, actually, they discuss how to withdraw, how to exit, etc. But yes, these are the ways to take care of. Miss Anjali, over to you, please.
Thank you, sir.
Thank you
Thank you
very
very
much,
much.
sir,
Thanks.
for such a
Thanks.
nice presentation and making this session very interactive. Sir, you are requested to please share the PPT with us.
I'll share it.
Thank you, sir.
Good day to you.
Thanks again. Thanks.